Welcome to yet another edition of Law and Order, brought to you exclusively by Channel I. It is the purpose of this show to enlighten you, our dear viewers, on matters which are of day-to-day relevance to you from the perspective of a legal expert in that particular field. And tonight we are going to take on a subject that sometimes confuses us because of the various nitty-gritties involved. And that is on the question of land acquisition. Now, all of us, we love to own a plot of land, and once we do purchase a plot of land, we are really glad that this is our little piece of earth that is our own. But there are instances when the government can acquire portions, if not the entirety, of your land, and that is through what we call land acquisition. Now, when something like that takes place, it can cause great anxiety to us because it involves the removal of a basic right of ours. But the law has provided for certain processes to ensure that our rights are not violated. To help us to understand what land acquisition is, why it takes place, and what the necessity for land acquisition is, we have with us an expert in the field, Mr. Anandalal Nanayakkara, who is a legal practitioner who counts more than 28 years in the field, and who is also a consultant with the Asian Development Bank and the World Bank. Mr. Nanayakkara, thank you so much for joining us here in the studios of Channel I.
Yep.
So yes, now we have two regimes of property ownership in Sri Lanka, private ownership and public. In what instances can a state take over property which is owned by a private entity?
Yeah, well, let's posit on more familiar terms, which is state land and non-state land.
Right.
State land per se has been defined by different laws according to the needs of that particular law. But state land in general, if you take the State Lands Ordinance, it talks of state lands as land that is available to the state, and so that's a very broad definition of what would constitute state land. And if you look at how land comes into the state land estate per se, the 1958 Land Commission report recognizes certain laws as the source from which land can come into the state land estate, and these are what's called the Crown Lands Encroachment Ordinance. This is 1840, old one. Then there's the Wastelands Ordinance, Land Surveys Ordinance, Land Settlement Ordinance, Crown Lands Claims Ordinance. Then there's Forest Ordinance, Land Resumption Ordinance, Land Redemption Ordinance, and finally the subject of today's discussion, which is the Land Acquisition Act.
So most of these laws have, sorry for interrupting, but they have been promulgated during colonial times.
Of course, most of them, some of them are repealed, some of them are repealed in part, and some of them are no longer applicable in full. But nevertheless, if you're looking at how does land come into the state land estate, there are multiple modes that through which that happens.
I see. So can the state take over property which is owned by a private entity on a whim, for example, on the whims of the Minister of Lands, or are there any criteria that have to be satisfied in order for the state to decide to take over someone's property?
Okay, again, just a little bit of interesting background to the question.
Please,
is that I was referring to the 1958 report of the Land Commission.
Yes.
The 1987 report of the Land Commission indicates that almost 80% of the land mass in the country is under direct or indirect control of the state, right? So that's a significant extent of land under state control, directly or indirectly.
80%.
Almost 80%. But be that as it may.
But that was in 1950.
No, this is 1987 report.
Right.
So thereafter, I don't think the current estimates are available.
Right.
But nevertheless, there are instances where it is necessary to acquire private land for public purposes. And the concept by which this happens is called eminent domain.
Eminent domain.
Yeah, eminent domain is the concept by which it happens, but there is a process, there is a law which facilitates that, and that's what we talk of as the Land Acquisition Act. And the current Land Acquisition Act is 1950, which repealed again a law that was over 100 years old.
I see.
But the current law is the 1950 Act.
What exactly is eminent domain, Mr. Nanayakara?
Well, eminent domain basically is where the state is entitled to convert to public use private land subject to the payment of fair compensation, right? So public purpose being at the heart of this acquisition process. It's also called expropriation in some countries. We use the term acquisition.
So it is not a concept that is unique to Sri Lanka. It takes place all over the world.
Absolutely not. No, it does take place in other countries also. It's not unique to Sri Lanka. We have our own unique approach coming from, well, some of these laws that we're talking of are what you would call legacy laws, because from a colonial legacy.
Yes.
So especially when you're referring to land, you have to be aware of that and as to why certain laws are structured in certain ways. But yes, the concept is applicable in lots of other countries. There are some countries which don't have properly developed land acquisition laws, and so then there is an issue as to how does the state acquire land, and they have to use either negotiated purchase or something like that. But we have this the land acquisition approach that's there.
So who exactly, the acquisition of land, who actually does that? Is there a particular official who is empowered by the laws of this land to take over property, or can it be done by anyone in the state?
Under our system, the principal approach is through the Land Acquisition Act, and therefore the principal functionary is the minister in charge of the subject of state land. And so that means that the Ministry of Lands is not the ministry that is always carrying out the activity for which the land is being acquired, right? So therefore, that means in most cases, there is a beneficiary entity, agency of the state, and there is the Ministry of Lands that carries out the acquisition per se on behalf of that particular beneficiary. So it's acquired and then transferred to the requesting ministry or agency, as it were. And in fact, a large number of laws which provide for either the state corporations and so on say that where land is required for the purposes of that particular government agency, it can be acquired in terms of the Land Acquisition Act. So it's referable back to the provisions of the Land Acquisition Act per se.
So for example, if provincial council decides that they are in need of land to broaden the roads in that area, in that particular area which comes under their jurisdiction, they can make representations to the Minister of Land?
Yeah, it might be depending on the purpose, the public purpose they're looking at, because you took provincial councils per se.
Yes.
If it is a direct state agency, then the process is more linear.
Right.
But if it is the provincial council, then it might become a circuitous approach.
Right.
But still, it would be the Ministry of Lands that would be the functionary that would carry out the acquisition on their behalf. Yeah.
Right. So this term public purpose is actually key to the entire process. Unless the property is used for a public or is intended to be used for a public purpose, it does not pass the criteria or pass the test that has been laid out by the Act. Is that right?
Yeah. Public purpose being the key operative word here. The Act defines public purpose in a very broad way. It doesn't identify public purpose by particular object. It basically says public purpose includes a purpose which under this Act or any other written law is deemed to be a public purpose.
So that's very broad.
It is broad. It is broad. It is kind of a circuitous definition, if you would look at it that way.
Yes.
But having said that, the courts also have sought to interpret on occasion as to whether a purpose is a public purpose, but it is a case-by-case scenario then. The reason for it being that it is very difficult, in fact, to encapsulate the concept of public purpose and to give it a definition per se. Some countries have tried to do that. India recently came up with a Land Acquisition Act which tries to define what public purpose is, but it's not an easy process to do so.
So, when you say public purpose, it has to, the intention for which the land is being acquired has to benefit the public in a broad sense.
That's right.
Is that correct?
Yeah. The purpose for which the acquisition is required has to be for the common good and has to benefit the public per se. In fact, if I may read from...
Please, yes. Thank you.
Yeah, it says that this is from one of the cases on land acquisition. The purpose of the Land Acquisition Act was to enable the state to take private land in the exercise of its right of eminent domain to be used for a public purpose, for the common good. Right? Not to enable the state or state functionaries to take over private land for personal benefit or private revenge. So, that's how courts have tried to interpret what a public purpose could be.
So that ensures that the property is acquired strictly for the benefit of the public and not on the whims of any official in the state.
Of course. And in fact, in extending this concept, now once we go into the details of it, we see that the process, how the process starts, there's a initial notice under section 2 and then notice under section 4 and so on.
Of the Land Acquisition
of the Land Acquisition Act. And even though the Act does not per se say that the public purpose has to be revealed in the notice, courts have held that when that initial notice is made, the minister has to decide on the basis of a public purpose, right? And then courts go on to say, if so, that means the minister has a public purpose in mind, and therefore there is no reason why that public purpose should not be made known to the public who are affected. And then it goes on to say that taking the scheme of the Act into consideration, that public purpose has to be revealed at that stage so that people will know why the acquisition is taking place.
I see. So you were quoting a judgment that has been delivered by our local courts,
yeah,
right?
Of course.
So that means that the decision for land acquisition can be challenged by a private individual in a court of law.
Yes, it can.
We'll
it
probably
can
go into that in more detail in our next session.
Yeah.
But with the increase in urbanization, we see huge infrastructure projects that have been embarked upon by the government. And this also has seen the increase of acquisition of lands. For example, even where I live, I find that there is this street line that has been marked. I don't know if that's what it is called, but you know, the yellow, with yellow paint, there is a mark that has been placed by the local authorities, which indicate that our road will be expanded for the purpose of developments, because there is the main road is going to be connected, and this is to make allowance for the development in the area.
Right.
So is it safe to say that land acquisition and development actually are two sides of the same coin? Is it essential?
Okay. Let me put it this way.
Yes.
Acquisition may be a corollary or a follow-up to land acquisition, but not necessarily so. Acquisition may be a corollary to development, but not necessarily so, because development may take place without acquisition. Clearly, you may not need acquisition.
Yes.
But if you put it in reverse, if there is acquisition, that means there is a clear development objective at the source of it, because it is only on that basis that acquisition can take place.
So what are the generally in your experience, Mr. Nanayakkara, what are the public purposes for which land is acquired?
Well, I mean, the most common that we hear of is road expansion, road extension, But it can be something like a public building, can be for public utilities, could be a hospital, public hospital, So the possibilities are fairly extensive, which is why it's difficult to capture it in a definition in a law.
I see. But as you pointed out earlier, the courts of our land have at least attempted to define the four corners of what a public purpose is in that sense.
Still, it will be approached as a case by case.
Case by case,
because
so it's not a one size fits all
it cannot be. It cannot be because of the different types of development that can come up. It has to be determined on the merits of each case.
Some time ago, we saw the Ceiling on Housing Property Act, where the quantum of lands that can be owned by a single individual is capped. Is that a form of land acquisition, or?
Okay, now that as well as if you take land reform,
yes,
right, which is a ceiling on agricultural land. Those are pursuant to socioeconomic policies of the government at the time, right? So that's a reflection of a certain program, social equity and so on. And that is not per se a land acquisition related activity, because in land acquisition, as we were discussing, there has to be a development objective which is directly linked to that land acquisition, and to which it is referable.
Now, say there is someone who wants to purchase a plot of land, and is there any way that they can ascertain as to whether there is a chance that this land or a portion of it might be acquired for the purpose of development and for a public purpose, so that they can guard against that, or at least maybe even look for alternate options, or negotiate the price of the land when entering into the purchase agreement?
Well, there is of course the non-vesting certificate that you request. That's a different thing, right? That is on assessment that there's no vesting happening. But whatever assurance you obtain will be valid as of that point in time, right?
So there's no saying.
No, it cannot. It necessarily cannot.
So what is the purpose of a non-vesting certificate then?
No, non-vesting is a different thing. That is that for non-payment of assessment, that it's not to be vested and so on.
But the non-vesting certificate is by no means a guarantee that this land will not be.
No, non-vesting has actually little to do with the acquisition aspect of it.
Yeah.
Because it can be acquired for a multitude of different purposes. So all you can do is to find out whether acquisition processes have been commenced. And if not, then then that guarantee is only valid as of that point in time.
Okay, so who can an individual seek clarification from on this aspect, on how they can find out for sure whether this plot of land is going to be acquired?
Again, if you want to assure as of that date, then it would be the Ministry of Lands would be the best approach.
And the provincial council or the local authority will not be able to
Local
assist?
authority may not know all the possible acquisition related activities.
I see.
But the Ministry of Lands might. I mean, you could check with them also.
I see. Okay. As I mentioned earlier, we see a huge increase in urbanization. But at the same time, we also see large swaths of land which is owned by the state in the outer areas, I mean outside Colombo. And these lands are used for such things as the protection of wildlife and so on and so forth. Those lands fall under a different regime, am I not? There is no question of a private individual being able to purchase. I'm kind of moving into a slightly different area in the sense of we are talking about how a state can acquire private property, but there is no question of a private individual being able to acquire title to state land in that sense, unless it is through a permit or something of that nature.
Yeah, unless it is through the process in the Land Development Ordinance, for example. There's the permit and then converted to a grant subsequently. But that is nothing to do with land acquisition per se.
There is a certain degree of confusion that that the general public have when it comes to these two separate regimes of property ownership, public and private, and I think it's oil and water. You can say that it does not mix unless unless it is provided for by the law. Would it be correct for me to put it that way?
Yeah, but oil never becomes water, right?
That's right.
But here one can become the other.
Right.
And when you're talking of state land also, I think there is a necessity to understand that, as I said, the word state land is defined by different laws according to their necessity, but there are also a large number of what are called public corporations. They may be called authorities, they may be called boards, but the fact that they are incorporated gives them legal identity, what we call legal personality. And because they have legal personality, they can hold property in their name, so that authority can hold property in the name of the authority. So which means then they can negotiate and purchase.
I see.
Right?
I see.
So that is distinct from acquisition. So there is that which is purchased by those authorities and in their own name.
But not an acquisition which comes under land acquisition.
No. But most of the laws by which these corporations are established will say that they can go for acquisition also. So they may negotiate. If it fails, they may elect to go for acquisition.
Unfortunately, that is all we have time for, ladies and gentlemen. Thank you, Mr. Nanayakkara, for joining us in the studios. Next week, Mr. Nanayakkara will be joining us once again, when we will be delving deeper into the Land Acquisition Act and the processes involved in the acquisition of private property by the state. Thank you for joining us, ladies and gentlemen. We will see you next week at the same time. Good night.